All right, welcome back. All right, before I get started, I want to begin by going over that question which we spent some time on at the end of class last night. But before I do that, I want to show you an email. I emailed the editor of the book right after class and complained about that question. And I want to just show you what he wrote back.
Wow. Hi, Josh.
Just this sentence is enough. I think I agree with everything you wrote. Okay, that's all you need to see at the beginning. I'll show you the rest of it later, so you know I'm not making this up. Okay? I don't know where all these stupid chairs come from. It's very annoying. They don't put this away. It's actually a hazard because I can trip and fall. All right. So go back to your book. It's on page, was it 685? I think it's 685. Yeah. All right. I put the question on the board too, so we have an easy reference for it. So 685, right? You're number 2. So the question says, O conveys Y dagger to A, who does not record. O then conveys to B, who purchases in good faith for consideration. Right? At the time that B purchases it, he's bona fide. Right? He has no notice. Okay? After B purchases it, A records the deed from O to A and sells to C. Okay? C also purchases for good faith and it's bona fide. Everyone with me so far? Okay? B records and C records. Everyone with me? Okay. The first question, which I think was a lot easier, was who prevails in a notice jurisdiction? B or C? Okay? In a notice jurisdiction, if you are a subsequent bona fide purchaser and you take without notice, you win. Right? The second in time beats the first in time. So in this case, C was a subsequent bona fide purchaser who took without notice. C prevails over B, even though C failed to record first. Because in a notice jurisdiction like Texas, it's not necessary to record first in order to prevail. You just have to be bona fide without notice. Okay? Everyone agree with that one, right? Okay. So far, so good. And I don't have any objections to the way, I don't think anyone have any objections to that first one. But the second part of the question is what gave us difficulty. And now I know why. Okay? So before I go further, turn to page 684 of your book, please. 684 of your book, please. Okay? Now I want a show of hands. I want you to be honest. How many of you read footnote 9? That's what I thought. Okay, I appreciate your honesty. And Anna, she stuck around last night for a good 15, 20 minutes talking this through, so I appreciate that. I complained that footnote 9 contains an important piece of information which no one will read. Right? So look what he wrote back. By the way, he teaches at the University of Chicago, which, you know, it's a good law school. He says, I tell my students to always read the footnotes. And what do I tell them? They're not going to read the damn footnotes. But he said at the bottom, you've convinced me that the stuff in that footnote is significant enough to put it in the actual text. Okay, so now let me tell you it's in the footnote. And we'll explain it. Okay, so if you go to page 684 and do footnote 9, right? This is a footnote talking about a notice jurisdiction. It doesn't tell you about race notice, but it says in a notice jurisdiction, there's something called the shelter rule. I'm telling you it applies in both notice and race notice. So the stuff I'm telling you in this footnote can apply in both a notice jurisdiction and a race notice jurisdiction. I never bother teaching because I think it complicates things and it's not really useful, but you'll know what it is now, called the shelter rule. Okay? And what does that mean? Let me go back to the question, I'll explain it. In this question over here, right, A was bona fide, right? A acquired it without notice, and A recorded first, right? Everyone understand what I'm saying? Under the shelter rule, C steps into the shoes of A. In other words, if A was bona fide and recorded first, then C gets the benefit of A. It's called the shelter rule because it's an exception to the normal recording statute, right? Under the recording statute standing by itself, right? Under the recording statute, by itself, B wins. Why? Because B recorded first. C's failure to record first means C cannot win. It has to be B, right? For C to win, C would have had to, number one, be without notice. Okay, that's a check. And number two, record first. That's not a check. Under the recording statute in California, race notice, C loses. But if we apply the footnote rule, the shelter rule from footnote 9, C steps into the shoes of A. And because A was bona fide recorded first, as does C. Okay, but now you see why I didn't teach you that one. And a couple of people came up after class and you did it differently last year. And I thought back, and the reason why is the shelter rule complicates it, right? It adds a layer of complexity that ignores what the actual recording statute says, right? In other words, if you just assume the shelter rule's there, it basically kills the point of the recording statute because you're not looking at each party and what they do. That's why I didn't try to teach that to you last night. And maybe I should have made a note of saying it. And a couple of you watched the video and you pointed it out. So for the class watching me next year, I'm sorry in advance. But there are going to be two separate questions here, right? And the way I told Lior to do it, or Lior's the editor, and by the way, he said I could show you this email. I'm not doing it without his permission, but he said I could do it, is, okay, right. I think I agree with everything you wrote. The answer to problem 2 depends on the shelter rule. So I said ask it two different ways in the book. Ask it without the shelter rule, and then ask it with the shelter rule. Your approach makes good sense to me. So from your questions to my comments to the 10th edition of the book, okay? I know it doesn't help you, but at least now you understand why.
If we can't sell our book back,
you have a little bit of time, but the 10th edition comes out in about a year, so you can sell this semester back. What's your cut? You have no cut. I don't get any cut. By the way, I send him edits and comments all the time. There are a lot of errors and mistakes in the book and stuff, and I flagged him. He's always he's very nice. And by the way, this is the 10th edition of the book. The first edition came out in the 80s, right? So this is an old book with stuff that's just been there for a long time. And when you have an old book, people just don't fix stuff. It just kind of builds up over the years, right? So that's this question, right? The answer with the shelter rule in place is that C wins, because C gets the benefit of A's bona fide status. Without the shelter rule, just the normal recording statute, B wins, because B recorded first. Yes, Angie, and then Catherine. On the exam, I'm not going to ask about the shelter rule. I think it's stupid, right? It's not stupid, but I would have to ask you under the shelter rule what happens. Because if you look at the question, it says the recording statute. It doesn't ask you about the shelter rule. They're assuming that you read a footnote a couple pages earlier that discusses in a different context this rule without telling you that they're asking about it. So I'm not going to, but if I was going to, I would say, in this jurisdiction, the shelter rule applies. But I'm not going to do that because I think it deviates from what I'm actually trying to get you to learn. That makes sense? Which is why I think the question as phrased was bad. Right? Exactly. And that's why I told him by email. The question changes 100% depending if you have shelter rule or not. And this is the question trying to teach you how the recording statute works. And instead the answer turns in the stupid exception, which they mentioned in a footnote, that isn't very important. Okay. Catherine?
So just to go back and clarify the answers, under the notice statute,
C wins. Under the notice statute, C wins over B.
Because there's no record of B's purchase.
Right. C was bona fide.
Okay. And then under race notice, B wins over C because B recorded before C.
That's correct. C did not record first. Yeah.
Know that there's this little exception
Shelter
out
rule.
there, but we don't need it for the exam.
I think that's a fair thing.
Fantastic.
Okay. Yeah, Waji.
So an application in either jurisdiction, race notice, and in this situation that we had in this hypothetical, is the shelter rule applied often, or is it more of a minority thing?
I'll be frank. I don't even know the answer. It's almost like this. It's an exception to recording statutes, and I'm not sure how often it's applied. Again, the reason why they put in a footnote is it's not very important, but they made the entire question turn on something that wasn't very important. So I don't know the answer, and I'm not going to ask you about it if that makes you feel better. But just so you know, this thing does exist. Okay. And again, I spent like an hour here last night or Tuesday night trying to figure this out. Then I finally came through. No, a couple of you were very kind with your time to show me what you're thinking, and I appreciate it because I hadn't quite seen it the way you were asking it. And once I saw it, I was like, oh, that's what they're not seeing. And then I emailed Lior that evening. He replied this morning. So there it is. But anyway, take it from him. Always read the footnotes. You won't. But anyway, so it will be fixed for your predecessors. Your subsequent book buyers who will buy without notice of this error in the book, I guess you could say, unless you record it and you note it in the. Okay, I'm going to stop. Okay. I'll get you in a second. I know you had a question. Anything else on this problem number 2? Get it now? I think you better get it now. We spent like 30 minutes on it. Okay, and Corbett, you had a question. I didn't mean to cut you off, but I wanted to start the class and get
No, well, I can ask you after class.
You sure?
Yeah.
Okay, that's fine.
It's about life.
Life estate. Oh boy, that's property 1 stuff. All right, that's fine. I'm teaching life estates, and I'm starting fee simple stuff on property 1 on Tuesday, so they get that going soon. It's not that bad, actually. I don't mind it. All right, anything else? It was hard to teach at first, but it gets better. Okay. Questions on the recording stuff from last week or last class? Okie doke. Okay, let's move on then to today's stuff. My poll question was actually based on this question. I'm not going to give it to you because we've beaten it to death. Please sign into the attendance. I think most of you have already. Okay. All right, so let's start the questions for today. Class number 8. All right, the topic today is what's called chain of title. Chain of title. Now, the phrase chain of title has a couple different meanings. So this term often gives students some confusion. So last class, I described the chain of title as the linkages from D to C, from C to B, from B to A, from A to O, right? I described that sequence of purchases as the chain of title that describes all the transactions from the present to the past. But chain of title has another meaning. Chain of title describes the period of time for which you must search records. That is, if you're doing a title search and you want to claim to be a bona fide purchaser, you have to do some minimum level of searching. You have to search some scope of documents, right? Whatever that scope of documents is called the chain of title. It's the stuff you have to examine. And if you fail to examine it, you're on the hook, right? Now, maybe I can give you an easy example. What's not in the chain of title? Spelling Elliot 5 different ways, right? The courts are not going to expect you to spell Elliot 5 different ways, right? So all the different variations of Elliot are outside your chain of title. You don't have to make that kind of an insane search because that's simply unreasonable because it's such a common name spelled different ways. But what's in your chain of title? Well, think of one of the cases we have today where there's some deed that says, well, there's this other deed that got lost somewhere. We don't know where it is. right? That's putting a note saying, huh, something's going on. Maybe I should do some more homework, right? Maybe I should look around for this Maud character and see what other transactions she engaged in, right? The concept of chain of title is your way of saying, as a reasonable person doing these searches, what should I be on the lookout for? And if there's some hints that things don't quite line up, you have to follow those leads. You don't have to follow every possible lead, like Elliot 5 different ways, but there's some reasonable leads that you can follow. So let me give you an example. It's easier to give an example than try to describe it. If you go to 692, please. And there's an example, I think it's example 7. There it is, yeah. Okay. Who's next? Where did I finish last time? You, you guys never remember? Is it you? Malin? Malin, right? Okay. Malin, you want to read number 7, please? Example 7? Okay.
Open base to A, who doesn't record.
Either way is fine.
Open base to B, who refers the A to B deed. Open base to C, a purchaser for value who has no actual knowledge of the deeds from O to A and from A to B. C reports who prevails, B or C. The issue is the A to B deed properly recorded so as to give constructive notice to the world?
Okay, Malin, so let me ask you a question, please, right? O conveys to A. That deed's not recorded. Okay? Then A conveys to B. Right? And that deed is recorded. All right, now here comes a big point. When C wants to buy Blackacre, what's the only name that C knows about? Who's the only name he knows to check?
B. No.
Will C know about B's name?
Yeah, because he records the A to B deed.
Well, how will they know to search for A or B? How would C know to look for A or B?
It would just look for the record of the title.
But how would he know to use their names in a search, though? What's the only name that C knows?
The name of the person who sold it.
And who's that? Who sold it to C? Oh. Oh. So let me try it. Yeah, I knew it was about to click. I was like 1 inch away. Let me ask the question again. What's the only name that C knows here? Does C know about A or B?
No.
Will he be on any obligation to search for A or B?
I don't think that he has a obligation.
Okay, that's right. A didn't record the O to A deed. There's no way for C to know about A. There's just no way. As far as C is concerned, O is the owner. Right? O is a crook, to be sure. But as far as C is concerned, O is the owner. There's no knowledge of A and B. Therefore, we say that the deed, the A to B deed, the A to B deed is outside the chain of title, right? We say that the A to B deed is outside the chain of title. There's no obligation for C to investigate that deed because there's no way for him to find it. He wouldn't know it exists. As a result, Malin, just finish it up. Is C a bona fide purchase for value without notice?
Yes.
Yes, ma'am. C is bona fide purchase for value without notice. He had no notice, nor was he an obligation to find the A to B deed. So therefore, if we were in a notice jurisdiction, Rebecca, let's just say we were in Texas. Right? We're in Texas here. Who would win? Who would win here? B or C?
C.
Yeah. C prevails over B because C was a subsequent bona fide purchaser for value without notice. In fact, here C actually recorded, which is not necessary, but C prevailed. I think actually, let me make sure before I shoot my mouth off. I think C would also win in a race notice jurisdiction as well because C recorded first. But it's not needed to record here in Texas. Lacey, is that a hand or a scratch? All right, blessing.
In the base jurisdiction,
In a race jurisdiction, you're asking?
Yeah.
That's the North Carolina and Louisiana one, right? Well, in the race jurisdiction, C would also win because B never recorded that deed.
Oh, he said he did. He reports that A, B, D.
Well, A, okay, so hold on. A recorded it, but B didn't.
No, B reports it.
A,
Pays to B, comma, who.
actually, it's not. A conveys to B, he records it.
Who should refer exactly to the antecedent should be B.
You know, I read that as A conveys and A records. The same, and A records A to B deed.
Generally, it's exact. That would be a dangling modifier. I think it modifies exactly before the comma. I thought B's. I mean, that's, I think grammatically it's supposed to be.
You know, I read that naturally, right? Now we're getting into grammar, but by the way, most lawyers are terrible writers. You probably know this by now. I read that as if it was A conveys to B and A records. In other words, the who
But they would need
refers to A.
It would need to say and A records for that to be B records.
That's ambiguous,
Or
though.
just and records.
I think that's ambiguous enough. Email. Email.
And he's gonna.
Keeps me mad. I got one more for you. You guys should get a cut of this. I'm sure. Yeah,
Let's just say it's B who records.
okay, yeah. If it's B records, then in the race jurisdiction he'd lose.
Who C would lose.
Okay, one at a time. Let me just. I'll finish that later. And just copy that. It's on page 692. Don't flood the guy. He's nice. He's very nice. He responds to my emails. He's very nice. Doesn't have to. Okay, so let's just pretend B's one who records. If B records before C in a race notice, in a race jurisdiction, then B will prevail, and in race notice, B will prevail. See, I read that as A records that deed, which he can, right? A can record the deed, but that's really ambiguous language. Anyway, Jessica.
Okay, so I think what confuses me about that is, I thought with race jurisdiction, it was like the exact same seller was selling to two different people. So I'm selling to Chris, and I'm selling to Holly and Holly.
It's always going to be O, A, B, and C. It's almost always this exact same format.
But in this case, like there are two different conveyors, right? O is conveying to C, and A is conveying to B. So to me,
Yes.
they're parallel transactions. I'm confused about why.
Right, who prevails, B or C, right? They're both subsequent buyers.
And even though they're subsequent buyers, right, from different people.
Yes.
Okay.
Yeah.
So the first to record wins.
Yeah, and by the way, going back to the question we had earlier, I complained about another part of the language. This sentence, A then records and conveys to C, that's terrible grammar. It should be A conveys to C, then C records. Or then A records. In fact, part of the confusion was who's actually recording in the sentence, right? A's recording. That sentence is clear. In the example we have here, it's not clear who's doing the recording. So what I would say is A conveys to C, and then A records, which would be an accurate sentence because you convey, then you record. You don't, right? Or,
Previous one.
right, or are you saying A records the A to B deed?
No, A recording is the O to
Right. So the sentences are just very poorly constructed. Yeah.
On the essay, you're going to specify.
I am so freaking clear. I am so clear. No, this is okay. So I'll give you my writing tips. This is Josh's writing tips, which you don't have to adopt, but my writing tips. One concept per sentence. I try really hard not to have multiple verbs in a single sentence. I just gave you a sentence with many verbs, but when I write, every sentence is one verb. So there's no doubt about what you're doing. I would say A conveys to B, period. B records the deed from A to B, period. And then there's no doubt. This is a crappy sentence. This is a crappier sentence, right? This one right here. Which one is it? Yeah, this is it's a very poorly constructed sentence, right? Because it's not clear who's doing the recording. I think it's clear, but there's if you guys are lawyers, right, and you write a sentence that can be read reasonably two different ways, you failed. You failed, right? If you're a lawyer and you write a sentence that can be reasonably read two different ways, you've not done your job. And this one, anyway.
When I was going through the problem,
Who's who?
Because I immediately thought B is the one who is recording the deed of A to B.
Yeah.
Immediately, like, that was horrible. That wasn't even the thought.
Yeah, yeah.
I think it's B because in the next sentence it says Oakton raised to C, comma, a purchaser. So you know a purchaser is C. That's why B is the person who records. Like that's how I read it that way.
That's plausible. Yeah.
Is it always I thought it was either the seller or the buyer could record.
They can either or both of them can record. That's true.
So it's still the, have the same effect, right?
No. If the seller records, right, that doesn't help the buyer. The buyer has to be one to record. Because the buyer is the one who needs protection. Once a seller sells, he's out of the picture. He doesn't care anymore. Right? It's not his problem anymore. Man. This chapter is going to get some work. Oh, I'm sorry, Mike.
No,
Who has a hand? Oh, I'm sorry. Classroom complaint. You're just not my line of vision. I'm sorry. You're peripheral. Like I can see I can kind of see you and I can kind of see Randall. That's as far as I can see peripheral. Yeah.
So just to clarify, assuming, so that we all have to write in our notes, assuming B is the one that
Record. B would win in a race and race.
B would win in race notice, and C would win
Yes.
and notice.
Yes.
AKA.
Yes. Man. But you can see, let me try and maybe make this a little bit more charitable. You can see how lawyers who draft these instruments don't use precise language, and then it creates litigation down the road because it's not clear what their intent was. Right? You can imagine a lawyer uses the word who after a comma, and it's not clear if it's modifying A or B. Right? Like I give Blackacre to my son and my daughter, who, right? And which one's who modifying? Anyway, so I'm going to repeat what Catherine just said because she's correct. In a notice jurisdiction like Texas, I think C wins. In a race or race notice jurisdiction like California, North Carolina, or North Carolina's race notice is California, I think B prevails. Okay? And that's assuming the word who modifies B and not A. I think that's probably the better reading, but I think I could see the other one going as well. You thought it was A.
No, I thought it was B.
You thought it was B.
Yeah, I was like, what the hell? You got me so confused for a second. I was like, oh my gosh.
See,
Okay.
I honestly, I read as A. Maybe I'm the outlier, but if I was reading that sentence, I would read it that A was one, because A, in other words, the verb is matching a single person. I would say A conveys and records.
Yeah, but that's what they would have to say for that.
See, I don't think I would need the word and.
But like grammatically, it's
I-
exactly
yep.
right before the comma that's modified by.
I ordered the pizza and ate it later.
That's
right?
different. That's different.
Yeah.
That's different.
A conveys to B.
Who records?
A ordered the pizza. Who ate it?
That's fine, but that actually wouldn't work.
A ordered the pizza from B. Who ate it? It doesn't make any sense.
And then
Okay,
B
I'm gonna let
ordered
this go.
pizza.
I'm gonna let this go. I'm gonna complain though. Okay.
I think you're gonna lose this one. This one's not as good.
All right.
I was with you.
All right. Fine. All right. Can we move on? All right. I can say I'm wrong, but I read that as A, but I'll let it go. Okay. I still think the sentence could be better. We agree on that much?
No, these are many sentences that could be better in this book.
If you find those, tell me, because I email him like maybe a dozen times throughout the semester. I don't tell you all the time, but I send him lots of little emails of things that don't make sense.
Okay.
There was an error. Do you know in I'm letting you know, there's an error in one of the graphics. We'll get to it later. Where I'll point it out when we do covenants. There's an error in one of the graphics I have in the book. I'll point it out later. The cases. I think Terry, you're next. All right, Anna or Terry, I'm not sure, but okay. Okay. Do you want to give me the facts in Lewis versus Superior Court? Yeah, I don't have the hand. Yes.
So I guess the
Can you hear the facts?
Oh, okay, okay. So, Lewis contracted to buy residents from Shipley. They opened an escrow account and acquired title. Montana films another buyer. Subsequent buyer. Recorded before the Lewis's.
Okay.
And I guess, but the Lewis's pay cash and the other buyers, I guess, financed it. So at first it was an issue, it was the question of whether or not that makes a difference.
Okay, that's mostly right. Terry, tell me, what's a lis pendens?
A notice of lawsuit affected title to the property.
Okay, what does that mean?
I guess like a lien or something?
Close. So imagine that you have sued someone for some amount of money, and you expect to win a lot of money. And you probably guess that the person doesn't have a lot of assets, and that if you win the lawsuit, you'll probably take their house to pay the judgment, right? You want to put the public on notice that this lawsuit's pending, right? Because if someone buys the house, they may be walking into a situation where you lose it, right? You walk into the house and there's a judgment against it, right? Because lawsuits can take years to wind through the courts, right? By filing the notice of lis pendens, you're putting potential buyers on notice that there might be a lien on the house in the future, okay? So the facts here are kind of messy. They're really messy, in fact. And it all involves a leap year, which is never good luck. It's a leap year this year, isn't it?
Yes, it is.
February 29th, yeah.
It's all about them.
Is it? Oh, wow. Okay. Do you even just go to that? Yeah? Okay. All right. So here's the timeline, right? In February of 92, the Lewis contracts to buy the house from Shipley for $2.3 million. Okay? Now, this is important. On February 24th, Fontana records the lis pendens. Okay, February 24th, they record the lis pendens. What does that mean? He brings this record to the county office, right? He brings it to the office. Is it indexed right away? No, right? The person who's actually responsible for putting it inside the book or electronic, whatever they have back then, right, does not index it till February 29th. I guess he wanted to be cute with the leap year, right? So he indexes it on February 29th. All right. So the question here is this, right? Anna, on February 25th, Lewis paid Shipley $350,000 on the contract. On February 25th, was this lis pendens deed available to the public to be found? Oh, Nicole just got back. I'll get back to you in a second. Yeah, I just stopped. Okay, I'll get you in a second. Yeah, but Anna, on February 25th, when this payment was made, was there any way for Lewis to know about this lis pendens?
No.
How come?
Because it wasn't indexed.
That's right. All right. So everyone agrees that when the $350,000 was paid, this deed was not within the chain of title, right? It could not be known. Okay? But then on the 28th, they closed, right? And they gave Shipley a note for 1.9 million. Okay, again. So Nicole, on February 28th, when they gave them the note, was there any way for the Lewises to know about the lis pendens?
No.
Okay, tell me why again?
Because they hadn't recorded it.
It was recorded but not indexed. Just be careful. The recording is what you do when you bring it there, right? But the city or the county hadn't put it up for public notice. Everyone with me? Okay. Yeah.
So in the book, or in the end of the first paragraph, it says the lis pendens was not properly recorded until it was indexed.
Yeah, and just
Indexing comes after.
I just so let me just get the terminology straight, right? Recording means you bring it to the office and they take it in, they put a stamp on it or something, right? Index means it's added to the grantor-grantee index. Right? Remember those two big musty books, right? I don't know if it was electronic at this point. Let's just assume it was in book form. They didn't write into the book for that 5-day period, right? And that's something by indexing, actually putting inside the indexes, the grantor grantee index, right? Yes,
So
just.
it would go with Shipley's name, I guess. You'd put it as like with Shipley, or would it, like, as far as the grantee?
If you were Fontana, the only name you know is Shipley. It's not clear that Shipley even knew who the Lewises were.
Oh,
I don't think.
I thought Shipley was selling it to them.
yeah, the Lewis is paid off the debt to Shipley.
I'm sorry. Right. So if you're Fontana, right? No. The debt was against Shipley.
Right. So Shipley, so they go to the grantee
Right.
index. They're putting it. I just wondered whose name they write down when they write this down.
Well, who's they? Who are we talking about?
The Fontana. So they go put they go register record
Right.
this thing.
They put Shipley.
The guy in the office writes Shipley and writes this judgment thing against it in the
Yeah.
grantee index.
Yeah, and it would list Fontana as well because Fontana is the holder of the interest.
Okay.
That makes sense?
Yes, I
Yeah,
thought
yeah.
it was a different kind of index. I didn't realize it could hold.
Right. When I say grantor or grantee, it could also be mortgagor or mortgagee. It's someone who's in interest against someone else.
Okay.
Yeah, Kate.
This might be a silly question, but what exactly does it mean when it's put on notice?
Fontana was trying to put prospective buyers on notice that there's a lawsuit pending against Shipley. And if for whatever reason there's a judgment that's set aside, that property can be seized to satisfy that judgment. Let me put it differently, right? Let's say I own a house for $2 million and I just got sued for a lot of money. And then after I got sued, I conveniently sell my house to someone else, right? That is a no-no, right? If it's shown that you sold the house to try and get away from the judgment, or you got rid of your asset, people can actually go after the house later, right? You can't sell your assets when you're about to face a judgment in a court. That's what's called a fraudulent conveyance. And the courts can actually reverse the sale. So the purpose of a lis pendens is to tell people, hey, you think you're buying this house on a good deal? You may be buying as part of a fraudulent conveyance, which may be set aside subsequently. That makes sense? All right. The goal of the lis pendens is to put people on notice of the lawsuit and that there may be a fraudulent conveyance issue. Do you remember a case last semester called Sawada versus Endo? It was from Hawaii. It was a family law case, right? Where you had this a guy who got into a car accident and he injured these other people. He had no assets other than his property. Then he conveniently gave away the property to his kids to try to, get away from the judgment, right? And the question is, can you set aside that judgment? Here with a lis pendens, you're saying, wow, I want to buy this beautiful house in California for $2 million. It's a great deal. Ooh, this may not be kosher, right? There may be some sort of fraudulent conveyance going on. Let me not buy this house. That's why lis pendens exists. Yes, Tom?
My apologies. So the goal of this pendant is to put a family on notice on the buyer, prospective buyer on notice. What was the second part?
That the land they're buying may be part of a fraudulent conveyance, right? To try and discourage people from buying this. So in other words, you're trying to keep the asset where it is pending the lawsuit. You don't want the asset to disappear into the unknown. Yes, Hubert?
But isn't what would happen that the seller and the buyer would pay the people with the lis pendens instead of the seller?
So here Shipley, are you saying Shipley would pay Lewis?
No, so if the Lewises were purchasing a home, so they would give the funds to,
Shipley.
well, not to Shipley, but if there was the lis pendens, wouldn't they?
But here, where'd the money go in this case?
Well, went to Shipley.
Yeah. And Shipley disappears. We don't know where the money goes. In other words, Fontana wants to make sure that if this property is sold, he gets it, and not Shipley. Right? That's to make sure people know that there might be some superior creditor floating around, and that this is maybe not the transaction you want to do.
But then he can just sue the Lewises?
What Fontana would do is say it was a fraudulent conveyance and try to set aside the sale. Right? In other words, Shipley dumped this on short notice to try and get away from the judgment. And he was judgment proof, right? He could declare bankruptcy and walk away. He has no assets to satisfy the judgment. I know this, you may not have exposed this, but debtor relief, right? How to go after debtors is very important work, right? I know it sounds awful, you're trying to kick people when they're down, but there are entire lines of attorneys who do nothing but try and figure out how to get money from people who don't have it. It's extremely common work, and you'll deal with this at some point. How? When your client doesn't pay the bill, right? It will happen. Clients sometimes don't pay their bills. If you don't have a retainer, you have to go after them. And you refer to collections, and then you figure out different ways of getting the money from them. So even attorneys who think they're upright human beings have to use this stuff eventually sometimes. You're smiling, but it's going to happen. Yeah?
So back to Jessica's question. So how would this get recorded in, like if it were a book?
You would basically note that Fontana, he's not the grantor, but he's effectively treated as a superior interest over Shipley, right? So if you're doing a title search on Shipley, this will pop up and it should flag that something's off.
So it'd be like a new entry, or it'd be a new added to Shipley?
Right. The book I showed you is very simple. It's just grantor, grantee. But in reality, there are many different types of entries you can make. It's not just one line. I showed you that book because it's simple, but you can have sophisticated entries. Right, you can have a mortgage with 3 different banks, right? There are different ways of indexing these things. Yes, Angie? I'm sorry? Of course. Yeah. Well, it's yeah. I mean, there will probably be a lien in the future, but it's not there yet.
So where would it be recorded in like modern times? Where would it be recorded in the credit report?
I mean, you might have it in your credit report, but where's this property, right? It's recorded in the grantor-grantee index in the county. Yeah, Mike?
So this is all based off of conjecture as far as like, well, I might win this lawsuit.
And there'll be 5 years of appeal, yeah, right? So there's certain unfairness to it, right? You can have a frivolous, I mean, look, there's abuse here, right?
That's exactly what I was thinking.
You can have a frivolous lawsuit designed to jam up someone's property,
Yeah.
and then you try and settle with them to get rid of it. This can be abused. I don't want to pretend this is always, debt collection can be very, very,
That's exactly what I was thinking.
Yeah.
right, I mean, so you could file a frivolous lawsuit, file one of these things when people are about to sell their house, jam up for a settlement to get this off their records. I don't know how common it is. I have no idea, but the risk for fraud is real. I'm going to agree with both of you.
So would that explain like the homestead protection rights? For your primary?
Well, you're going way off field, but in general, if you're selling it, it's not your homestead anymore, right? The entire point of this case is he's selling the house, right? If you keep it in your own name, you don't have to worry about it. In other words, if you keep the house yourself, this doesn't really matter. You're not conveying it. It's only if you try and dump your house. Oh, I'm sorry. Were you raising it right behind me?
No, I just had a question.
Okay, you can ask it.
So for like today's property assets as they get conveyed, is the grantor grantee index not by address?
No, that's what's called a tract index. Remember, by location. We don't have that in most jurisdictions. It's all by names.
Even
Right.
today?
You can search electronically for an address, but you still need to look for names.
Even today.
Yes. Right. Modern records are going to be electronic, but once you get past maybe the 80s, it's all on paper, and you need to go back year after year after year. You don't like that answer?
Well, I'm just thinking of like a house getting conveyed. The house is tied to an address.
Right.
But if you're looking in terms of land, yeah, that land is not tied to
Well, addresses change, right? You can have a house that's demolished and condos are built there in their place. So addresses aren't always gonna be perfect, right? Things move around. Yeah. Let's keep going. All right. I think. Okay. So on February 28th, Lewis receives the deed and he records. And there's a note for $1.9 million. The next day, the 29th, the thing is indexed. Okay. So now in March of 92, Lewis pays off the end of the note. Right? Again, he didn't use a bank. He actually basically borrowed from the buyer. Right? It was a loan from the buyer. Okay. Then he renovated the property. Then in 93, Lewis is served in Fontana's lawsuit. Because Fontana said, hey, you bought this property knowing there was a lis pendens, therefore you're party to the lawsuit. Mike's shaking his head real bad this time. Like, look, if you buy a piece of property and you're on notice about lis pendens, that's proper, right? It may not be something you like, but you took a property knowing there's a risk, right? The lis pendens ensures that future parties can be brought into the lawsuit. So that's why you're saying don't do it.
But he did.
And that's the question, right? So this is a case from California, right? Demetrius, what do we know about California cases? What do they always do? Oh, I called on her.
Common law.
I'm sorry, what?
Common law.
What about the common law?
So, so in this particular.
What do California courts do to the common law?
They use the common law.
No. Opposite.
They did not use the common law.
What do they do to the common law?
They don't want to.
What do I say about New Jersey courts and California courts? What do they do to the common law? Always. No, AJ?
Is this in any way referring to the whole race notice, or is this?
No. I'll come back to you. Yeah.
New Jersey always.
No, they don't use it.
No, they don't. They override.
Okay. We eventually got to the right answer. Yeah. New Jersey and California courts always reverse the common law. Consistently. Reverse. Yes.
Reverse with an A.
Reverse. Reverse. They overrule the common law.
Oh, I always thought you were saying revert.
Revert.
I just always.
Anyone else hear that? Revert.
It might just be that. Sorry.
Okay. Well, if I wasn't clear in my speech, I apologize. Reverse. All right. So come back to Demetrius. Okay. What was the common law rule in California before this case?
That there was notice at the time of the last payment.
Yes. Right. At the time the last payment was made, Demetrius, in February of '92, was the deed indexed?
Yes.
So under the common law, did they have notice about this list pendant? Okay. So under the common law, this is to Mike's objection a minute ago, they were properly served, right? So imagine you're a debt collector lawyer in California and say, success, right? Index February 29th, they made their last payment in March, suckers, I win, right? Okay, but we're in California, AJ, right? And what is the California? By the way, this is not the California Supreme Court. This is the California Court of Appeals. So even the intermediary courts are doing their own thing, right? AJ, what does the court do here?
The Court of Appeal held that this pendant was not properly reported until index. Are you talking about the end of all of this?
My question is this: does it matter when the last payment was made that the deed was indexed? Does that put them on notice?
No.
Okay, tell me why not.
I thought it was because they purchased it free and clear.
When they made the last payment, was the deed indexed?
Yes.
Okay, that's right. Does the court think that they were under an obligation to check when the last payments were being made?
No,
Why not?
because it was indexed. Because it was indexed before they made the last payment.
No.
Because it would be a undue burden. If
Yes.
you continue to have to check out.
Yeah,
the payment.
that's right. Under the common law rule, you effectively had a duty to check every time a payment was made, right? Every time you were going to make a payment, you had to go down to a title search. The common law rule. The court says the common law rule is unreasonable. It creates too much burdens, right? Under the modern rule, the California approach, so long as you do some sort of check at the outset when you first start to acquire the property, you're fine, right? And this is unique. You're actually paying it to the seller, right? If you had taken out a mortgage with a bank, this would not be an issue, right? Why? Because the title goes to the bank right away in its entirety. Once you buy it, the title goes to the bank, and Mr. Shipley's out of the picture. But because they were taking a note out from the seller, he was still actually the title owner. Okay? So what the court does here is they reverse the common law, and they hold that there's no duty to check every single time you run through a payment. Okay?
Bless you.
All right. Everyone get the first case, Lewis. Yeah, Mike.
Is it just pure luck that Lewis, the day he bought it, it's indexed the same, that is luck or?
Completely luck.
Okay.
Right? I mean, imagine, I think I had an exam question like this a couple of years ago. The guy, Fontana indexed it like at noon while Lewis was doing his title search, right? He was in there with all the books, the dirty books, and like as he was in there looking through the books, this one thing gets added at the end, which he already passed through. In other words, he already checked from 1992. This guy was going back to the 1800s, and it was added at that point, right? Then you have to look at a timestamp. But you do have cases where you have things being recorded on the same day or different times of day, and you have to actually check at what point was it indexed. Was it available? If he had searched the book at 9 a.m. and it was added at 10 a.m., then it was not in his chain of title. It was beyond his reach. Yeah. But I do want to return to a point Mike and I think Angie raised a few minutes ago. You can screw with people with this, right? You can just follow these things and just extract settlements, right? A lot of debt collecting is basically how to exert pressure and extract a settlement, knowing you're not actually going to court, right? I met one debt collector lawyer, and he once told me the one line he uses is going to be evil, but he uses this line all the time to get what he wants. He says, "How long have you had your dog?" See, exactly, and that's when they say, "All right, fine."
Wait, you possess it or something?
Yes, a dog is personal property. Can you repo the dog? No, I know.
I'm not sure it's
Look. If the sheriff shows up with a writ for your dog, you're not going to shot the sheriff, right? And you got the deputy also. Yeah. Yes. Hold on, AJ. Yeah, go ahead.
Okay, this case confused me because I didn't know why they were suing, like why Fontana Films was suing at all. But just to get the dates correct, on the 24th, Fontana Films reported.
Okay, let me just check my notes. Let me make sure I get you the right dates. Okay, on the 24th, Fontana recorded the list pendants. That's right.
But it wasn't indexed until February 29th.
That's correct.
The closing took place on the 28th.
That's correct.
Sorry, the Lewis is paid Shipley on the 25th. Took place on the 29th.
Yeah.
But it wasn't.
No, the closing was the 28th.
Okay, 28th.
Yeah.
And then on the 20th, it wasn't indexed until the 29th.
That's correct.
I get what the court held. I don't get why it matters.
Well, let me ask you the question like this, AJ. If, let's say Fontana recorded the list pendants on the 24th, it was indexed the same day.
Okay.
And then the next day, Lewis pays for the house. Would Lewis have been on notice about the list pendants then, if it was indexed on the 24th?
They would have said that he should have been on notice.
Not said, he should have.
been on notice.
It would have been in his chain of title.
Okay.
And if it was in his chain of title, could Lewis have been added to the lawsuit?
Yes.
That's it. Right? The fact that it was not recorded, the fact that it was not indexed for those 5 days is a difference between Lewis being in the lawsuit and Lewis being outside the lawsuit. That's why it matters.
So while you're buying your property, you need to check. But as soon as you have that title.
Under California law now, once you buy it, you're clear.
Okay.
You don't have any duty to check a second time. Yeah, I mean, if you probably don't know these title companies, but they do searches as close as possible to the closing as possible. Right? They try and do it right up to the date because things can change. Right? Imagine the day before the closing, the guy sells your house to some other guy. Tom.
Are you conveying, just like deed and title, that you gotta know we have to for your essay? Like, that's what you're trying to convey right now?
Say it one more time, please.
Like, so you know how like we get deed and title, or you know how students get deed and title confused? Well, you know how recording and index, I can see how.
Well, look, yeah, I mean, those are not the same thing. I mean, I don't know if I'll care so much about those words, but I can say, A brought the deed on the office on the 24th, but wasn't indexed till the 29th or something. That's a fair question. I know I've asked a question, like I told Mike a few minutes ago, where in the same day, people are modifying books at different times, and I've asked those sorts of questions before, and they get messy. Oh yes, Catherine. I'm so sorry. It's just you're not my range of vision. I have to turn.
So for when they talked about like the substantial payment, do we just need to be worried about the date?
Don't worry about that.
is?
Yeah.
Okay.
It's California too much. Don't worry about that one too much. All right, let's move on. All right, the next topic is what's called inquiry notice. Inquiry notice, okay? All right. Inquiry notice it's a duty, right? What are the things that you should be aware of, right? And there are three kinds of notice, right? The easiest one is called actual notice, right? For example, if I tell you, hey, O's a crook and O sold Blackacre to 3 different people, right? If I tell you, that's easy. That's called actual notice. Okay? Actual notice is fairly rare, right? If someone tells you that O's a crook and sold Blackacre to 3 people, you're not going to buy Blackacre. So you don't see actual notice very often. The second type of notice is called record notice, right? Record notice is where you go through the grantor or grantee index like a responsible person, and you find, oh wow, there's a list pendants here. Oh wow, there's a mortgage here, right? You do your homework, right? This is the most common kind, right? You do your due diligence and you figure things out. But there's a third kind, inquiry. This is the hardest one of the three and the one we'll focus on next, right? Inquiry notice occurs when there's some facts that don't line up, right? There's something that doesn't make sense. And a reasonable person would make an inquiry saying, what's up here, right? Why are these things not lining up? Right, to use the example from the Harper case, right? There's a reference to some missing deed. It's like, that's not normal. I've never seen that before, right? So it's almost a reasonable person standard. What would a reasonable person do if confronted with this sort of unclear facts? That makes sense? All right. The next case is complicated. I don't want to sugarcoat it, but the facts are a little bit messy. Xavier, I think you're next. Sorry. You want to give me the facts, please? At least start it off. The facts are kind of long. But the facts in Harper against Paradise?
So, in this case, Susan Harper, which was the original owner, she conveyed a deed to her form to her daughter-in-law.
Right.
For $5.
This is Maud, right? We had this other case with Mildred, and I kept saying Maud. I was thinking of this case, actually. Okay. And what kind of interest did you give to the daughter-in-law?
The warranty.
Oh yeah, right, it was a warranty deed. That's correct. But what kind of estate was transferred?
A life estate, right?
Which one is it?
Life estate.
Okay.
She
She gave a life estate to Maud, and who is the remainder? That's right. Yeah, Maud's named children. So this is straight up a life estate to Maud, remainder and fee simple to Maud's kids. All right, go on.
So it was lost.
Okay.
We found in the trunk of Maud's car.
Was it? Okay. Was it? Yeah. Okay. So the deed was lost, and it was missing until 1957. So for basically like 50 years, the deed just no one knows where it is. Right? This stuff happens. Right? It sounds. You don't believe it? You don't believe it?
No, we're first in the case, sorry.
Okay. All right. Go on, Xavier. So far, so good.
So after it was found,
Well, let's stay in the 20s, okay? So after this deed was lost, what did the children of Susan do?
they executed a new deed,
Good.
conveying the property to her. What they were trying to convey the property to her in that deed, they indicated there was a prior deed.
And when the kids gave it to Maud, what kind of estate did they convey? Right, the original Susan deed from 22 was a life estate. What kind of deed were they giving her in 28?
It
Yeah, you're right. You're right. Say it.
The fee simple to mod after.
Very good, very good. Okay, thank you, Xavier. Very good. All right, so we have a situation where in 22, Maud gives a life estate to Mildred. No, not did Mildred. Susan gave the life estate to Maud, and the remainder to her children, to Maud's kids. Susan dies, and Susan has 4 kids. 3 of the 4 kids say that they're giving a fee simple to Maud. Now, Avery, let's pretend the 22 deed never happened. Could those 3 out of the 4 kids have possibly conveyed any interest? Could they have given a fee simple? Why not? Right. So this deed was sketchy to begin with, right? Usually you need all 4 heirs to convey. And there may be other heirs, we don't even know. But at least these are the 4 kids. Now, Avery, why do you think they went ahead and gave this to poor old Maud? Why do you think they did this?
I don't really know why. I figured they just didn't. I don't know. They didn't want to.
Yeah, Michael.
Didn't she need money so they gave her so she could mortgage it?
I don't think that's why they gave it to her. I think she did that without their knowledge. Well, I'll come back to you in a minute with the mortgage, but you're right. That happens next. I think they just felt bad for her, right? They, Susan gave her this deed. They lost it, and they kind of feel bad for her. And they decided to give her a fee simple. They probably didn't want the house anymore, and that was fine, okay? All right. But in the deed, the 28 deed, they reference a lost deed. They said a deed that's been lost or destroyed and cannot be found. Okay, that fact proves to be significant a little bit later. All right, Michael, so now go on. What happens a couple years later? We know that Maud is deeply attached to this land and thinks so highly of it. What does she do?
She mortgages it.
For how much?
$50.
I know, right? 50. And what happens to that loan?
Then she not paid off. Now it's up to a sheriff auction.
Right. So she puts the entire land on security for $50, and she can't pay off $50. Oh, Elisa's not here. But I mean, people go into foreclosure for very small amounts. It is not a big amount. I mean, even in the 30s, that wasn't like a huge amount of money to go lose your property. The deed goes into foreclosure. A sale is held, and the sheriff sells it to Paradise. I'm sorry, the sheriff sells to Thornton, and then 20 years later, Thornton sells to the Paradises. Okay. At some point in 57, the deed is discovered. Magic. And the deed's recorded 50 years later, 1957. Okay? There's no obligation to record a deed right away. It at any point. In fact, I think at my exam last year, there was a 100-year gap between a recording and a transaction. You can do it. There's no limitation period. Okay? And then Maud dies in 72. So Allah, let me ask you this question. Were the Thorntons on actual notice that something was wrong here?
They were because of the language and the deed they were.
Was that actual notice?
Oh no, they're on constructive notice.
Yeah, I think they're on constructive notice. I think it'd be what you call maybe inquiry notice, right? Right? And the reason why I think the Thorntons were on inquiry notice was because they knew that the foreclosure sale happened to Maud. And if they did a title search for Maud, they probably would find the deed from 28. And the deed from 28 referenced this missing, destroyed, or lost deed. So I think the Thorntons were on some sort of inquiry notice. And I also think the Paradises were on the same type of inquiry notice. Therefore, Waji, if they were on inquiry notice, can they claim to be bona fide purchase for value? Are they BFPs if they were on inquiry notice?
On inquiry notice, they did not do their legally obligated duty.
So are they BFPs?
They would be
Are they bona fide purchase for values?
No.
That's right, they're not. Right? Even though they were subsequent buyers, they can't claim bona fide purchase status because they were on notice. And because they can't claim bona fide purchase status, they lose. They can't claim protection. Yes, Corbett?
So they saw this deed, the one that took the place of the lost one.
Yeah.
But when you're looking at the books, you wouldn't see that.
Right, which is why I don't think it's record notice, right? They learned other stuff because they were aware of this deed, and that's what you put them on inquiry notice to inquire further, right? They could have maybe called up the 3 kids and said, hey, what's this deal with this missing deed? You want to tell me about it, right? Now, ultimately, right, they can't claim protection by the recording statute. So, Matt, which was the controlling deed then? The 22 deed or the 28 deed? Yeah. And then what happens by virtue of the 22 deed? Who gets Blackacre? What was the original intent of Susan Harper?
Maud's children after Maud's death.
And when did she die?
She died in 28, 57.
No. Maud died later.
Oh, I'm sorry, 72.
That's right. So basically, the paradises are lost by May, right? Sorry. I'm sorry, I'm done for the night. The paradises lose, right? Because the remainder now goes to Maud's kids, right? Now, Designate, what's maybe one other argument the Thorntons or the Paradises could have raised to save them? They've been there for a while, right? What else could they maybe argued? What's that argument? And by the way, this is an easy test style question I'm giving you right now. What else could the Thorntons and the Paradise have argued about why they actually own Blackacre? Yes. Why? So tell me what the argument would be.
They were on the property for was it the 10 years?
It was a lot more than 10 years, almost like 20-something years, right? Okay. So now, let me ask you this question, Desnay. When they were on the property for 20 years, whose interest were they squatting on? Who was the owner at that point?
They were squatting on Maud.
Maud. And what was Maud's interest in the land?
Maud had
A life estate. Can you adversely possess a life estate? Probably not. Why? Why is it a bad idea to adversely possess a life estate? That's it. Yeah. Once Maud dies, the remainder kicks in, and they've not squatted on the remaindermen. Right? The squatters, Thornton and Paradise, did not squat on the kids of Maud. So they get it free and clear. So this land now belongs to the Maud's kids. Okay. Had the case been differently, right? Had there been no reference to this 1922 deed, I think that the Paradise would have been a subsequent bona fide purchase for value. But because they were on inquiry notice of that little one sentence, they lost their house. And Maud's kids, who probably had no idea what any of this even was, come out win. Right? This case illustrates, perhaps an egregious example, how serious inquiry notice is. That if you don't do your due diligence, you can get screwed. Okay? Okay. Questions? Was there a hand? Oh, I'm sorry, Rebecca.
So when the remainder kicks in, that's when the clock would start for adverse possession.
When the remainder kicks in, I think so, yeah. I mean, the problem is you can probably technically squat against someone with a life estate, but like if they die in the middle of your 5-year period, it doesn't matter. right? So it's generally you can't consider squatting against a life estate person. Okay. Okay. Questions on that? All right. Let me talk a little bit about title insurance. We've mentioned it many times, but it's an important thing that we should all just be aware of. If you go to the TDI, it's the Texas Department of Insurance, and every year or so, the government publishes the rates for title insurance, and it's fairly affordable. So let's just say that your property, is $100,000, right? Which most properties are, right? At least. Your title insurance policy is $875. Not very expensive, right? If you're over $100,000, I have these various formulas, which I don't want to bother you with, but it's fairly affordable. It's not terribly expensive, which is why these problems should not happen. If you want to, go by yourself and do your own title search, good luck. But I would not recommend it. Right? A title insurance policy gives you some sanity, some clarity. Okay? Title insurance policies only apply to the current buyer. It does not apply to a subsequent purchaser. So if I buy my house today with a title insurance policy and I sell it to one of you, right, you do not get the benefit of my policy. This ensures that a search is done on every time the property changes hands, a new search is performed. Okay? Not terribly important, but just so you're aware of how that works. Okay. Questions so far? All right. Let me summarize a bit, and I'll bridge for next week, and you go home a little bit early tonight. When we're talking about chain of title, we're talking about concepts. We're talking both about the sequence of transactions from the present to the past, but we're also talking about the sorts of things you should be on notice to look for. And that could be based on actual notice, things people told you. It could be based on record notice, that is things you find in the grantor grantee index. Or like the last case, it could be based on inquiry notice, things that should put you on notice that you should ask more questions and dig a little deeper, right? And if you have any kind of notice, actual inquiry or record, those documents become within your chain of title. And if you fail to find that document in your chain of title, you are not a BFP. You are not a bona fide purchaser, and you cannot take advantage of these protections that are afforded to BFPs. You're going to lose. So do your homework. All right? On Tuesday, we do nuisance. I suspect most of you did nuisance and torts already. The cases may be even similar, but we'll do them from a different angle. Okay? Anything else? I will see you all on Tuesday. Have a wonderful weekend.
Yes, here's the question.
Want to come up?